Good afternoon, everyone, and welcome to the third Dispute Resolution Dialogue. Today, we're joined by Shahan. He is a principal associate at DSK Legal, specializing in arbitration and dispute resolution. He will talk to us about the concept of tribunals, paranoia, as an impediment to arbitration. On to you.
Good evening, everyone. So, when we talk about due process paranoia, which happens to be a very commonly debated issue in international and domestic arbitration alike, we need to first understand why arbitration has become a preferred mode of dispute settlement across the globe. You get number one, flexibility in arbitration in terms of the procedure that you want to undertake. And the second is efficiency in terms of time and cost. Now, the analogy of understanding this would be comparing it to fine dining. At a fine dining restaurant, you wouldn't want to wait too long for the meal. You want a good food, and there should be good variety in terms of food. The service should be good, and the bill should be plateable and reasonable as well as transparent. If you get arbitration, again, you would want everything alike: the costs, timing, variety in terms of how you would want to adjudicate the dispute. So hence, it's a complete package that people expect when they do arbitration. And if any of this is missing, any of these elements, then the purpose doesn't get solved. Now, let's understand what due process is. Now, wherever we see it in terms of arbitration, due process hasn't been defined. But how do different commentators refer to it? Some say these are the most fundamental guarantees of judicial procedure which you require in a binding adjudication process, and which also gives legitimacy to a binding adjudication process. Eventually, it draws parallels to what we call natural justice. And how Gary Bond puts it is that due process are the certain minimum levels of procedural fairness that are required in an arbitral process, which include the right to be heard, the opportunity to present the case. And when I say opportunity to present the case is crucial because we'll deal with this word in various arbitration rules and legislations where the parallel to due process is drawn. Now let's see how it finds place in international arbitration. So let's start with the ancestral model law. Now, under the ancestral model law, Article 18, it says that parties shall be treated with equality and each party shall be given a full opportunity of presenting their case. Now, apart from this, under the New York Convention, the party against whom the award is invoked is required to be given proper notice of the arbitration and the opportunity to present the case. This also finds mention in Article 34 of the ancestral model. But this evolution was not so straightforward. Now, if you see the Travis preparatories of the Geneva Convention of 1927, the ICSID statute, as well as the ancestral model law, they recognize that the principles of due process, being notice, the right to be heard, and equality of treatment, were essential to adjudication. And this was narrowed down because in the ancestral model law, in the initial stage, the concept was available at any stage of the proceedings. And this notion that it is available at any stage was dispelled on account of the fear that such a broad notion would allow parties to frustrate and prolong the proceedings. And which we often see, and especially in court litigation, there are ample ways. And if you look at the CPC, it's a complete catalog provided to you to prolong a proceeding. You can file n number of applications and get the suit delayed as much as possible. Now, that is why this notion at any stage was removed. And what was focused upon was that the party should get full opportunity. This finds place under Article 15 of the ancestral arbitration rules, which refers to full opportunity. And any stage was reserved. So full opportunity was replaced by reasonable opportunity, like myself, and any stage was replaced by appropriate stage. So here it is very crucial. And when we come to different statutes, which I'll just come down to, you'll see the difference and discrepancies in different countries. Now, if you look at institutional rules, the HKIC rules, Article 13.1, Article 17 of the Uncitral Arbitration Rules, Article 14.1 of the LCIA rules, and Article 22 of the ICC Arbitration Rules. And they have an interpretation of due process where they only give a reasonable opportunity to present the case. But if you look at national laws, the English Arbitration Act, the old one, the tribunals shall ensure that the parties are given a reasonable opportunity to present the case. In India, the parties are to be treated equally and shall be given full opportunity to present the case. Now, the Singapore International Arbitration Act says the parties shall be given a reasonable opportunity to present the case. And if you take a cue from a civil law jurisdiction, the French Civil Code, the arbitral tribunal shall ensure that the parties are given a fair opportunity to present their case and respond to the arguments of the other. So here, we have come across three different words: reasonable opportunity, full opportunity, and fair opportunity. And why this is crucial is because as we proceed ahead, we'll realize that this paranoia, does it really exist or not? It eventually depends on how national courts have interpreted it. And the judicial matrix, depending on the countries where they have pronounced judgments, we would realize that it's more of a mind block that arbitrators have more than it actually leading to setting aside and vacation of awards. So the first formal discussion of this paranoia and concerning due process international arbitration started off with the Queen's Mary International Arbitration Survey of 2015. Now, I'll refer to this survey time and again because it actually is one of the very few surveys that comprehensively cover developments in international arbitration and have a very wide variety of respondents across the globe. And it gives us a very clear picture in terms of how things are happening. Usually the respondents are the same in different years, and they give a projection of how improvements have happened and how the concerns in international arbitration procedures are being addressed or not. So in 2015, they described the paranoia as a perceived reluctance by tribunals to act decisively in certain situations for fear of the arbitral award being challenged on the basis of a party not having had the chance to present its case fully. Now, according to the survey, this paranoia was an issue raised in nearly all interviews by the respondents when they were asked about the probable improvements in international arbitration. And the respondents to the survey attributed the increase in costs and lack of speed to this phenomena of due process paranoia. When we come to the 2018 edition of the survey, the phenomena, and they quote, continue to be a source of concern for many respondents. They expressed anxiety regarding the paranoia being a contributing factor to the minimal imposition of sanctions to curb its abuse. So here we see that not only have arbitrators alluded to due process, they haven't even imposed sanction like costs to reduce it in practice. And in the 2021 survey, the respondents felt that arbitrators continue to be overly cautious when it comes to due process paranoia. Now, why does it happen that over the years an issue has been raised and arbitrators continue to be paranoid when it comes to due process? It is because of the fear of the award being set aside. Now it leads to two situations. It leads to professional embarrassment and it affects the future prospects of appointment as arbitrators. Now here we're looking at a very global scenario where you have specialized arbitrators who actually get appointment in terms of their performance when it comes to the arbitration. It's not so that they are court appointees or you don't have a large pool of specialized arbitrators where you might rely on retired judges for appointment as arbitrators. Here we're looking at professionals who conduct arbitration as a means of livelihood, right from their mid-30s and 40s. So for them, it reflects in the future prospects if a lot of the awards are set aside. And not only that, if you look at different institutional rules, like Article 42 of the ICC arbitration rules, Article 30.32.2 of the LCIE arbitration rules, and 41.2 of the CIAC arbitration rules, there is an onus on the arbitrators to make every effort to ensure that the award is enforceable at law. So this adds to the unease, and that unease contributes to the compromise of the process. But let us be very clear that there is a corresponding duty on them under these rules to conduct their arbitrations efficiently as well. So it is not that while you have to ensure that the award is enforceable at all counts, you cannot compromise it at the cost of efficiency.
So, sorry, can you just unpack this paranoia a little bit in the sense? So, is there evidence that there are too many challenges on the grounds of a party not being heard, etc.? The one
No,
that you mentioned.
That is where I'm coming. Is this real or overstated? Now,
They are, so this is, for now, there is no evidence backing the fact that many challenges actually occur. But
so
they,
so as per the Kluwer arbitration report that covered multiple jurisdictions,
Hmm.
due process violation, or we call the inability to present one's case, was succeeded only of 11% of the cases examined.
no, succeed. The claim being successful is another thing. How many such challenges are even made on that?
That's right.
On grounds of due process, the success was 10%. That's what you said.
But effectively there are challenges.
No, but
Multiple.
what are the other grounds? And in comparison to other grounds, how much of
So if you compare the other grounds where, for example, invalidity of the arbitration agreement, or for that matter, public policy, fatal illegality, out of all of them under arbitral Article 34, it is only 11% success rate in terms of the total overall success. So it is a very small component.
So it's actually not really.
It is not a paranoia. It is in fact, so while in practice, now we look at two sets of statistics. Most respondents to an arbitration survey come and say that, okay, there appears to be a perceived reluctance by arbitrators. But effectively, when these awards are challenged, and there might be different awards, it is not a ground that really succeeds eventually. And again, it's a jurisdiction to jurisdiction approach. And I'll give you two examples. Now, the Singapore Court of Appeal in China Machine versus Jaguar held that the violation of due process requirements have to be examined within the boundaries of what a reasonable and fair-minded tribunal would have done in these circumstances.
So no, that I understand. I wanted to understand the percentage of awards that are challenged on grounds of due process. Now, the success rate I understand is
Yes.
11%. But what is the percentage of total? What is your denominator?
If you say that there are 5 grounds available for challenge, it falls in the latter half, plus 2 of them.
No, in the sense, is there a, how many awards are challenged on this?
No, that's just a stat I can't come up with, but if you look from so success rate is 11%, and if you ask me that out of, say, the 5 grounds available, the ones that I use more frequently, this comes in the latter half. So it would come at number 4 or 5 in a pool set of 5. Now then you have the Malaysian High Court. Again, they give very broad notions. So there are no strict guidelines given by judicial courts across the country that say that natural justice does not demand that a party is entitled to receive responses to all the submissions and arguments presented for the right to be heard is fundamental. So they don't, courts, whenever they have come up with challenges on due process, have not said that each and every argument has to be considered, as long as a fair-minded tribunal would have given them the opportunity. Now, how does the abuse actually happen? Now, in an arbitration, Lucy Reed has described due process as a sword, and some commentators have described it as a sword of Damocles on the arbitrator's neck, because they have a lot of discretionary powers in terms of procedure, and when they're overly cautious in terms of case management, then it can lead to an abusive due process act, which entails different acts by parties, which include insufficiently justified or multiple requests for extension of time. Now let us look at it from an Indian perspective. As practitioners, the most common reason for seeking extension of time is personal difficulty of counsel. It has never been described. Rarely anybody asks for the first time when a request is made on account of personal difficulty, they agree to it. Introduction of new or fresh evidence at an inappropriate stage. And I just cover these grounds and come down to a personal experience in a very high stake arbitration and how due process has been a problem. Then we have insufficiently justified requests for postponement of hearing or last minute requests for having a physical hearing or a virtual hearing likewise, and superfluous filings and unnecessary document disclosure requests. Now let us see it in context of amendment of pleadings. The law as it stands under the Civil Procedure Code, Order 6 Rule 17, you have, before trial starts, you can virtually amend the pleading at any stage. No matter how much time has gone into the arbitration, whether it's going on for 7 years, 8 years, it doesn't matter. Law is liberal to an extent where even in appeal, pleadings can be amended if just cause is shown. Now, under the Arbitration Act, I think it's section 23(4), if I'm not wrong, where amendment of pleadings is allowed. And I was researching for it. There's no judicial precedent to say what constitutes amendment within due time. So you refer to CPC. And virtually no tribunal before the trial starts would reject a request for amendment because if you refer to the principles under Order 6 Rule 78, you virtually have to allow it. So such approaches eventually undermine the process. And it happened so the pleadings were amended for the second time, right before the evidentiary hearing was to happen, and mind it, the arbitration was going on for 10 years. So you had international parties, you had an international tribunal who had to allude to that request eventually. Now, what are the impediments that it causes? It affects the legitimacy of the process. Because if there are frivolous or cynical invocations of due process in an arbitration, the whole process is undermined. People are not incentivized enough to follow that. Then arbitrators, they allude to these requests and sometimes they end up imposing increased costs, which is detrimental to the party on the other side. And there's an unconscious arbitrator's bias. Now, when you have vigorous, aggressive complaints in the form of guerrilla tactics, sometimes the arbitrator might be intimidated enough to act in favor of the party making such requests, or eventually they might develop a bias to act against that party on account of sheer frustration. Now, eventually what it leads to, this obstructive behavior, if it is allowed by tribunals time and again, it increases the paranoia. And the procedural flexibility that we get out of arbitration eventually enters into a state of, say, confusion and inconsistency. Because, again, you would have to examine it from the perspective of what a reasonable tribunal would do. And in the absence of any guidelines, different arbitrators would follow different ways. And as a counsel, as a party, you don't know how it would be responded to in an arbitration. Now, this paranoia leaves the tribunals with less incentive to impose effective sanctions, which have been now and again highlighted as a major disadvantage in arbitration proceedings by 46% of the respondents in the 2015 version of the QMUL survey. And which is second only to costs. The subsequent issues in 2018 indicate a similar trend where costs 67% and lack of effective sanctions 45% are the topmost disadvantages of international arbitration. Now, what has been the effect on people? In the 2021 version of the QMUL survey, 61% of the respondents were willing to forego unlimited length of written submission, which is why they wanted to curtail it to a certain number. 38% of the respondents were willing to forego oral hearings on procedural issues. 27% of the respondents were open to reducing or eliminating document production. Now, document production and discovery, as we know, in domestic arbitration is not a big concern, but in contracts involving years of services and history to it, document disclosures are a big pain. Trust me. Now, again, coming back to the effect, 24% of respondents were in favor of eliminating more than one round of written submissions, and 21% of respondents were able to dispose of it post reviews. Now, when the numbers come down, these are very critical aspects, because otherwise, when you want to have opening submissions, you want to have closing submissions, and you want to have post reviews. It's the standard international arbitration. People wanting to forego any of these three talk quite highly of this paranoia affecting them. Now, let's see in terms of how we can tackle this. There are no straitjacket formulas, and there are different ways, in fact, how tribunals can act against it. One is having reactive measures. Now, the arbitrators should recognize and promptly denounce attempts. Now, this may be in the form of a communication, an email, or a letter, but it is very crucial that, when a request which appears to be abusive should be rejected at the outset in a very stern way. And it would serve a very dual purpose, not dual purpose of warning the attempting party that the tribunal is alive to the conduct of the party and it understands what is happening. And it also gets the tribunal to record its response. And when they get to record a response, it is very crucial at the stage of challenge of the award, because then they would know at what reasons actually went into the tribunal rejecting such a request. It does not mean that there should be a lengthy explanation insofar as the tribunal is concerned, as long as they clearly explain the reason why they are eluding or rejecting a certain request. And prophetically, at the start of an arbitration, in fact, arbitrators should set the tone of the arbitration and establish the environment where such abusive are to be made. Now, there is work by Professor Klaus Peterberger and Dr. Ulla Jensen, which recommended that arbitrators should use procedural discretion to shape the arbitration in accordance with a few core principles. And they summarize it as: first is transparency. Now, from the commencement of the arbitration, the tribunal should make its expectations known, which includes that it firmly sets its face against dilatory or unreasonable conduct, fully expects the parties to play their part in bringing the proceedings to a swift end, and adopt a hands-on approach. The second is proactivity. A lack of active case management may encourage or provide opportunities to parties to make strategic due process complaints. The tribunal should therefore take charge of proceedings from the outset and actively seek the inputs of the parties. Utilize the procedural management tools at their disposal and apply cost sanctions in the event of unreasonable behavior. And last is interactivity. This includes continued communication between the tribunal and parties. And again, they should keep conducting case management conferences amongst them to monitor the proceedings and prevent unexpected last-minute requests. For example, right before a final hearing is to be conducted, there should be communication ongoing. Say, the cross-examination ended in June and the final arguments are scheduled for December. It does not mean that there's no activity between the counsel and the arbitrators. There should be active communications with tribunals where they should call out upon the parties to make any concerns that they have known to the tribunal. Because at the last, and if this continued activity happens, I don't think in the last minute, any request, if made, would seem to be viable. So then you sort of avoiding such situations. And again, like we see, there is no straitjacket formula for courts to determine or for tribunals to determine. It's actually active engagement with the parties so that their intentions are known is very critical. That's it.
Thank you, Shahan. So could you just elaborate through an example on how due process paranoia looks like in India?
An example to start off with would be amendment of pleadings. No tribunal would, considering the liberal law in the country, no tribunal would reject a request for amendment of pleadings, at least till the start of the trial. So while you may have had a change of pleadings, exchange of witness statements, process examination has not started. Even one day before the cross examination, I can request for an amendment of pleadings. Now, after I amend the pleading, there will be a subsequent round of completion of pleadings and witness statements will have to be exchanged. So effectively, you know postpone the finality of the case to about a year at least in that scenario, because this all would take substantially 6 months, and then depending on the availability of counsels and the arbitrators, you would end up spending another 6 months on that. So it effectively is there. No adjournments are very easily granted. As we know, costs in Indian arbitration as a practitioner, I'm not referring to statistics, but I don't see costs really being a concern for a lot of parties and lawyers alike. So the paranoia in terms of granting full opportunity, what would construe as a breach of natural justice, is fairly common amongst Indian arbitration scenarios.
Okay, understood. And you spoke about how you give an example of how crucial it is to respond to requests and elaborate on those requests.
That's right.
So do you think it's important for arbitrators to have a certain amount of qualification or a different practice, go through some
See, I
rigorous
think-
process?
See, I think it's a very dynamic sector, and there are global best practices that countries with more nuanced arbitration systems have followed. There is a lot of use of technology that countries are following, and in fact, when it comes to adopting best practices, Indian lawyers, Indian senior counsels, arbitrators alike are more skeptic to such suggestions. So, number one, yes, of course, an arbitrator needs to know the best practices, because here you're not confined within the four corners of code of civil procedure. You're mostly dealing with ad hoc arbitrations in India. So all the more it is important for arbitrators to understand that there is to have good systems in place, because you're not confined within institutional rules. You're not following any rules. It's a completely tailor-made procedure that you're making for the arbitration. So in India, it is very crucial that arbitrators get some understanding of how best practices can be adopted. Well, I wouldn't say that it requires a certain degree in educational degree for that matter, but adopting best practices would be the way forward for them.
So Shahan, there is an impression that, the background of arbitrators might matter for due process. And there is a perception that arbitrators who do not have judicial background, they may not adhere to due process norms, and their awards are more susceptible to challenges. To what extent this is true?
So again, when you talk about judicial background or the legal background, there's a huge difference in that. If we just say that arbitrators without a legal background, yes, I think they might overlook a lot of facets of legal philosophy, jurisprudence that are essential for the award to be upheld. But I wouldn't say that it is important that the arbitrator should have a judicial background as such. Because, of course, people don't really go ahead, especially in India with young practitioners as arbitrators. But a seasoned legal professional or a seasoned judge, irrespective, would be a good choice for an arbitration. So, and of course, across countries, because in other countries, I've seen technical people being arbitrators, and that's very crucial in specialized sectors. When you're dealing with disputes such as rare earth minerals minings, or for that matter, oil and gas exploration, there would be very little semblance to how much of legal knowledge is required, how much of scientific knowledge is required. Now, just if you already have, for example, you're following some institutional rules that have there are watertight. There are not many loopholes. Having a technical arbitrator would be perfectly fine, because while you can get basic knowledge of how an arbitration is to be conducted through those rules and the technical person would know it, you cannot turn a judge into a scientist to understand it. It's of the scientific process.
You spoke of a survey result, but that was an international survey, not limited to Indian jurisdiction.
Yes.
Is there any empirical study in the context of India that talks about success of challenges based on procedural grounds?
Not really. I came across few of them, but every data set had very limited respondents. Some were confined to government bodies. There was a survey on patent illegality, but again, in India, the focus has been more on substantive issues, more than procedural issues. So, while there were aspects in public policy in terms of patent illegality, but not on such procedural grounds. Whereas a lot of these are what get challenged on public policy as well, where there is absence of natural justice.
Oh, may I ask you
sure,
something?
sure.
So I'm not very familiar with arbitration, but I've been doing a little bit of work on tribunals
Right.
and on regulators. So a lot of regulators under the parent statute also have the liberty to set their own procedure.
Right.
And you were talking a little earlier about the balance between technical members and legal members. And it seems to usually be the case that where technical members end up making orders, they don't have even the basic elements of what would be considered a good order that is the result of due process.
Correct.
And then one of the things you fundamentally learn very early on in certain law is that it's not enough to follow procedure established by law.
Yes.
You need to understand the ethos behind due process.
Correct.
And I just can't help but wonder where would you draw that line? How can you say ensure that sort of flexibility remains without again making leading to situations where paranoia becomes so overbearing?
See, in terms of regulators, talking about regulators, I came across an order, and see, trust me, when it comes to due process, a certain bit of checklist, a certain bit of checklist, if understood properly, in a very short period of time, you can apply it in different situations. Now, a regulator, so in law, you have to put somebody to notice before you can put sanctions on them as a regulator. Now, what happened in this case, interestingly, was that a regulator caused a particular entity. That investigation was ongoing. In the middle, they decided to expand the scope of that, investigation. Now, ideally, what was they supposed to do? They had to show cause their separate cause of action. They asked some questions in a questionnaire. In the questionnaire, they asked for some information and eventually imposed a sanction on the entire bit without formally putting them to notice that you are being investigated for another aspect as well. So, drawing the line is very easy. In fact, merging the two is not very difficult if you have a certain bit of a checklist, a certain bit of understanding what is basically required. And these are very basic tenets of justice. And to say that it requires years of experience would be an overstatement. It requires basic sense of understanding that you have to let somebody present their case. You cannot confine them. Again, adjudication by technical people included an instance where there were 20 different parties, one of it's on the same cause of action, and they were all given 5 minutes to speak. So, while it involved a lot more time. So, these are experiences from my own personal legal practice, and what eventually I've understood is that if you give them a basic understanding of how legal process works, because this does not include legal interpretation, we include complex legal doctrines. It's basically a checklist that you set out what is required for the parties. The parties should be able to present their case. The parties should be able to meet the other person's case, and all of this should happen in time given.
I have a question. Do we have any safeguards against due process paranoia in the Indian law? I mean, does our law allow for some sort of waivers against overemphasis on due process?
No, I think the only way is under law is the discretion for the adjudicator to impose costs. Apart from that, there is no, because it would require a detailed creation of a specific provision to deal with such requests, which again, I don't think is practically possible. Because this is, in the real sense, it would depend on a case-to-case basis, and it has to be really seen in context of the history in terms of the parties' conduct. So, apart from imposing costs and serious costs, not most emotional costs, say a dispute involving millions of dollars imposing a lakh rupees of cost is nothing. It wouldn't be detrimental to anybody's interest. The cost has to be effective. It has to be proportionate. It has to be in terms of the paying capacity of the party making such a request. As long as the sanction is not stringent, you cannot expect any results out of it.
So there are two aspects. So one is the cost aspect. Let's say one party keeps on missing the timeline
Correct.
and doesn't file their pleadings. So arbitrator will impose cost. But the other thing is the arbitrator should also have the liberty of moving on.
Correct.
And saying that, okay, since you haven't filed your pleadings, despite two opportunities given, so now your opportunity is gone, and so we move on. But arbitrators in India, especially, and most of them are retired judges, and they were very skeptical, very reluctant to do that. So I'm not saying that the law should be very detailed and specific about it, but it should at least, how about having those principles in the law that the arbitrator right in the beginning could decide, and then,
So
reasonable opportunity and not full opportunity.
Correct.
So those
that
things.
would be there. And this, due process abuse not necessarily happens in the main pleadings. It happens through ancillary pleadings, like an application for amendment, an application to file additional witness statement, an application to say file, you at the last minute seek disclosure of certain documents that may or may not exist. And then the other party has to respond whether they have those documents or not, and then a procedural order has to be passed. So while pleadings, completion of pleadings, filing the first round of witness statements, XYZ things are concerned, that very well is covered by most procedural orders that tribunals pass. But for unforeseen instances like again, I told you these applications for XYZ things, arbitrators have to decide there and then. Well, because as much as they can set out a procedural case management order, if the parties will continue, if they want to delay the case, if they want to frustrate the other side, they would file such applications eventually. And it is at that point in time where arbitrators have to stick to it. I happen to know a recent case under the ICC rules where there was an international tribunal. It was international commercial arbitration with an Indian PSU, and the arbitrator at the outset rejected the request for extension of time to file the witness statement. The witness statement was not filed within time, and the proceedings went on. Whether that eventually it would survive the test of challenge if the award happens to be in such a manner that it is challenged by the party who lost out on the opportunity to cross-examine and submit their own witness statements. But it took a bold step, nevertheless, to ensure that the arbitration did conclude within, say, about 2 years. But this paranoia, apart from, you can set the tone. You can let the parties know about your intent about the arbitration. That has to be very clear. Like, as lawyers, people mostly know how judges would react to certain people. Different judges have different ways of handling their courts. And that is where senior counsels and the concept counsels we have who regularly appear before courts, they tend to know how a judge would react to a certain situation. In case of arbitrators, you may not be very familiar because there might be judges from different states or arbitrators from different backgrounds. So it is very critical that at the outset, the tribunal sets out that tone for the arbitration, and which gives a sense to of course, it depends on the person to person basis, whether they get the understanding of the tribunal, but at least they should make efforts to set out the tone of the arbitration so that they know how they're going to deal, how they will be dealing with the situation, and accordingly they would not fancy chances of alluding to processes that might be rejected by them. And of course, it will eventually depend on how they handle that situation at that relevant point of time.
So what we're effectively saying is that it is really about the tribunal or the arbitrator exercising control rather than anything else working, right?
Yes, it has to be their control. It has to be because, and of course, watertight institutional rules. Because one is the arbitrator setting tone. That's something not really put out in paper. But what is put out in paper are institutional rules, and any failure to follow the rules, then that may give a good defense in terms of a challenge because you're eventually the parties have accepted the rules. There is consent to be bound by the rules and they're not following those rules.
How exactly do you mean when you say set the tone? What exactly are you talking about here?
See, these are more like a soft skill or an interpersonal thing where you let the parties know that this is how I'm going to conduct my proceedings. And this is the manner.
Basically conveying your style.
No, but then that argument goes against the paranoia argument. You are saying that the arbitrator doesn't exercise control because they effectively think that it can be later challenged as
Because
on procedural
Correct.
grounds, and therefore, and then so I mean, if you think that this is the incentive, then they will never exercise control.
no, so the control is in terms of how he exercises it. So, for example, a request is made at the last moment. Of course, they would be scared, but if they give proper reasoning at that point of time in rejecting a request, it's one thing. But from the beginning, if a party knows that this tribunal might not budge, they've been very categorical. There was some sternness in the words in which they said in the procedural hearing that we will not allow these requests to be made. If you want any changes, they should be within a certain point of time. Then you would, at the beginning, be able to set the tone in place. There are two different scenarios. One is that at the outset, you present how you're going to be, and that might deter people from alluding to these requests. And number two is when it actually happens and how you handle it. If, of course, you're rejected by a one-liner, that might put some questions. There might be some sense the court eventually hearing the case would not be privy to what really happened at that point of time. What they would be privy to is a transcript, or what they would be privy to are documentation. And then again, something very critical here is that if you have procedural hearings, transcription is something very necessary. And it comes with costs. It's not really possible in a lot of domestic arbitrations where the value is not very high to have transcription services. But as a practitioner, I have found it very useful to have transcription. And that is where, again, the use of AI comes in, where you can agree to AI as a cheaper mode of transcription service.
Yeah.
Because a lot of words are used and then multiple things. Arbitrators bias. You can move an application under 14 at that point of time, but that eventually, okay, my request was not allowed. Okay, I wanted 5 days for cross-examination. They gave me only 4. There's a bias. I filed an application. There's a
Transcription would be super helpful.
the hearing, how it was rejected, the manner in what was said. Because let's be very clear, in affidavits, people speak all sorts of things in this country. You're not really eventually held accountable for the small words you speak and which speak a lot eventually. So transcription is very critical. And when you finally go in challenge in 34, because I know of what an order passed in terms of bias challenge by the tribunal is not appealable at the instance. You have to wait for the proceedings to continue, and then only you can challenge it. So at that point of time, how you respond to it is also very critical. That a detailed reasoning given by a tribunal. So you can be overly cautious, but by being overly cautious, you can use mechanisms that don't sort of destroy the efficiency aspect of arbitration.
But also, I mean, all this, I mean, this is an aside thing, but it also makes you question that maybe the purpose of arbitration is also not time and cost efficiency, at least from the party's perspective. Because if this is also being replicated in international arbitration, perhaps those are not the aims of arbitration. Is the way the parties see it. Because I mean, those dilatory tactics, as you were saying, using procedural grounds in a manner that can be, categorized as abuse. Perhaps they don't think of time and cost savings as the aim of arbitration.
There can be no other effective means otherwise. If it is not time and cost,
But you were saying that this misbehavior happens. Then what is the,
So two parties, one party's interest is to get the gain fast and the other party's purpose, so the interest.
so that's what I'm saying. So I mean, that misalignment
Yeah,
is the same even here, like an adversarial process, like in the sense that it's not very, you can't really distinguish it very much like that.
Perhaps the only advantage then would be like the flexibility in choosing what those would be. And being like, hey, I want this.
see
that.
flexibility in terms of you want your case heard at 2 p.m. for 3 hours. And if that happens in the court, no, not necessarily.
So maybe these flexibilities, these minor
Right,
things, but the
again,
aims are still
See, here
questionable.
they're looking at very different expectations. We're not looking at expectations in the Indian scenario where where the norm is 10 to 15 years of, that's a very low figure I'm saying for suits to be decided. 10 to 15 years is the average time for a suit to be decided. So the expectation there is 2 years, 3 years for a dispute to be decided. So comparing that, it's very different. So if it becomes 3 to 5 years, it's a big thing for them. Because their expectation is speedy disposal. But if you look at it from a domestic Indian litigation scenario to international arbitration, it's like apple to oranges, because for them the notion of time and cost is much more expeditious as compared to an Indian scenario. And of course, both parties have their times and costs, but when a case pans out and how submissions are made and how disclosures happen, there is incentive for maybe one of the parties to avoid the adjudication at that point of time.
But perhaps there is a sense of comfort in having these proceedings sort of replicate how the courts work. Say some manner of
I
like,
think that's because the common bridge here is the lawyers.
yeah, I think
Retired
And
judges.
retired judges.
Yeah.
I mean, at least domestic arbitration, I don't think, because it's the same sort of misbehavior where you seek adjournments, it's the same here. And I don't think the interests of lawyers are aligned with the time and cost efficiency of things.
and
Lawyers again, because it depends. You put it in different scenarios. Internationally, you have contingency fees, success fee. Lawyers want the case to be decided. In India, you have either Ali billing
Or appearance.
or Ali billing, that is say particularized billing, Ali billing or per appearance billing, or you have a lump sum fee. In both, you have no incentive that the case gets decided at the earliest. Because if you're getting paid X amount of sum, you're getting paid X amount of sum, it takes 5 years, 6 years, whatever. And Ali billing, more the merrier. But again, contingency fee and success fee, I don't know how ready we are as a country as in terms of having ethical standards for the profession here and the enforceability of those ethical standards in the country, whether we can have those fee mechanisms. But globally, arbitration is headed towards a scenario where you have success fee as the norm. Parties don't wish to pay for, hourly billing anymore, except for very, very high stake disputes. And in fact, Singapore and Hong Kong recently did do that. And one more thing is very clear that while arbitrator fee might sound to be huge, but globally, the major component of cost is lawyer fee. So the more pleadings are filed, the more documents are filed, the lawyers are making more and more money. And that is where the cost angle goes up.
and perhaps parties are also more comfortable when these elements are present.
Elements such as
Elements such as more paperwork, they're like, oh yeah, my lawyer is doing something.
depends on how smart the party is. It really depends on how smart the party is. I think clients today are very, very they have a lot of exposure. They're very clear in terms of what they want. India has started finally accepting the notion that you need to have good specialized in-house counsels, not just company secretaries. Companies have specialized lawyers to handle their litigation in-house. They have specialized lawyers doing the compliance work under the Companies Act. So I think the Indian client is more well aware than it ever was. And they really question you on each and every statement that you're making, and they really try not. It's one of the times when we would make long pleadings so that the client is satisfied that okay, the lawyer has worked on it. I think they now try to keep it very simple, especially the corporate planning industries.
That's a paradigm away from litigation. But
Does anyone online have any questions? Before we close the session.
perhaps the AI reader has.
Okay. I guess not. Yes. Thank you so much, Shahan. That is wonderful. And thank you for sharing your insights and answering the questions. Thank you.